The third consideration in a divorce is alimony. It's the third issue that the court has to determine. There's several different types of alimony in Florida. Just because there's a marriage and a divorce doesn't necessarily mean that alimony is appropriate. There's several factors to be considered by the court in determining whether alimony is appropriate and in what amount. But here are the basics. The main components that are utilized in determining whether alimony is appropriate are the length of the marriage, the need of one party for alimony, and the other party's ability to pay. Now, certainly there's more complexity to it than that, and we'll get into that in the alimony section. There's several factors the court's going to review and consider, but those are the basics. Okay, so the different types of alimony. Here, the most common, most well-known type of alimony is permanent alimony or permanent periodic alimony, as we call it in the statutes. That's the type of alimony that lasts for essentially forever. It lasts until either of the parties dies or the party receiving the money either remarries or cohabitates. Now, there's instances where alimony can be modified generally and extinguished potentially based on other circumstances, but we would get into that further in an analysis of your case during our consultation, or in the alimony section. We'll get into a little more detail in that specific video. The next type of alimony is the next longest period of alimony generally would be durational alimony. Durational alimony is appropriate under our statutes since July 2010. When permanent periodic alimony is not appropriate, durational alimony may be appropriate. Okay, so, and it's typically ordered in cases where, or typically appropriate in cases where the marriage is between 7 and 17 years. The date of marking or measuring that is going to be from the date of marriage to the date of filing the petition for dissolution of marriage. So durational alimony, there's some statutory caps on it. You can't have durational alimony ordered for a longer period of time than the marriage actually lasted, and a few other components that we would discuss in regards to your case. The next type of alimony is rehabilitative alimony. Rehabilitative alimony, as the title implies, is for essentially rehabilitating someone back into the workforce. The idea is to put the person that's receiving the alimony in the same ability to earn as they were when they entered the marriage. So this is for a shorter term marriage typically, and the rehabilitation that we're talking about is typically additional schooling. There's a rehabilitation plan that has to be laid out, and it has to be illustrated to the court how it's going to put the party back in that position. The next type of alimony, and again we're getting kind of shorter in duration and scope as we go, is called bridge the gap alimony. Sometimes this type of alimony is referred to as move-out money. It's statutorily capped as of 2010 at 2 years. It can't go longer than 2 years, and it's really just kind of get you back on your feet type of alimony. They're typically ordered in shorter, moderate term marriages. And the idea is to, get you out and on your feet, and maybe it's paying a few $1,000s for move out. Durational alimony is often called move out money because it's often a few $1,000s, which is essentially money you can use on a first, last, and security of your next residence. And the final type of alimony available in Florida is what's called nominal alimony, and that's essentially alimony of $1 a year or $1 a month to keep the door open. Now, what does that mean, to keep the door open? Well, if there's no alimony ordered at all, then you can't in the future modify to create alimony in the future. So there has to be at least $1 of alimony, what's called nominal alimony, ordered to kind of keep the door open so you can come back and modify. So when would nominal alimony be appropriate? Well, you might have a marriage that's a long-term marriage where permanent periodic alimony typically or would generally be appropriate, except that the party that has traditionally earned a substantial amount of money, substantially more than the other spouse, is suddenly unemployed, and it's expected that that party would go back to work and be able to earn that amount of money in the future, or a substantial amount of money in the future. Permanent periodic alimony may not be appropriate in that case, and so a nominal alimony would basically leave the door open for when that spouse went back and did find the employment, making a lot of money. You'd be able to go back and modify in the future. So those are the types of alimonies that we have in Florida. Again, every case is different. There are many factors to be considered under our statute. There's plenty of case law that help define what's appropriate and what's not. We really, to give you a good sense of your case and where you stand, we'd really need to have a consultation and understand more about your case. So if you have alimony issues in your case, then I encourage you to set up a consultation. Child support is a little more straightforward in Florida. It's not a super complicated area of the practice. It's not a very complicated issue. So there's only a handful of factors that go into calculating child support on almost every case. There's two different methods for calculating child support, and the different methods, which method to use, is based on the first factor, and that's the time sharing of the children between the parties. When the parties both have at least 20% of the time sharing with the child or children, then you would use what's called substantial time sharing or the gross up method for calculating child support. And that just means that within the equation, you're also considering the percentage of time that the kids are with one parent versus the other. When you utilize the model plans for Palm Beach County, then both parents are going to fall into this spectrum of substantial time sharing. So you're going to use that equation. You're going to consider the time sharing between the parents. But if you're outside of that, if one parent has less than 20% of the time sharing, then you're not going to include that component or that factor at all. So the remaining factors are this: the income of each party, and that's the net income. There's under Chapter 61, there's a breakdown of what is considered in gross income, which is essentially all income. But there's allowable deductions that you can subtract out of that, and it's essentially taxes. It's your own health insurance expense, and that's mainly it. There's a few other things: mandatory union dues, mandatory pension contributions, but there's the gross and there's the net. So when you get the net figure, you're going to run it through the equation, consisting of, or you're considering the other issues of if there's health insurance for the children, how much it is, and who pays for it. And if there's child care for the purposes of employment of one or both of the parents, and who pays for that as well. And these are really the components that are part of that child support equation.